Hi, good afternoon, everyone. This is Rajiv S. Khanna for immigration.com, the offices of Rajiv S. Khanna PC. Um, we are going to be talking about LCAs. Most of the discussion will be at a level that is, I believe, very practice oriented. I'm not going to get into the details of the law, and I'm not going to get into any esoteric, complicated issues that cannot be easily complied with unless you have a PhD in law. So we're going to keep it simple. Please make a note. Anytime you have a question, please press star five. Star five. As I'm talking, anything that comes up, press star five on your phone and I will unmute you and take the question first. This discussion that I'm going to do could be done in as little as 10 minutes or it can be done in 10 hours. I am going to take the approach of finishing everything up in between 20 minutes and 30. So we have plenty of time for question answers. And I'm more interested in knowing what is bothering you at a practical level and to make sure I can suggest some solutions that would work for you. As you guys know, this conference was um, by invitation only. Most of the people here are existing clients. There are human resources people. There are people who are CTOs, in-house counsel, as well as other people in the staff, HR people who are involved in this process. Um, so that said, some of the people who have just joined in, let me just confirm that you understand. You have any question at any time while we are talking, just hit star five and I will take the questions as we go along. That way, we just want to make it a conversation. As you have, many of you have attended these conferences before, we keep it very simple, we keep it very straightforward, informal, but structured. That said, let me get started. Um, I wanted to talk very broadly about what LCA requirements are, and I want you to ask questions. And please give us your stories, what you have seen, what you have heard, so we can all be enriched by your experience. I remind you once more, you would have heard all this when you logged in. There is a recording that tells you that this call is being recorded. I strongly recommend that you keep your identities confidential. We don't need to know who you are. I can, of course, see everyone, but we don't need to know who you are. I'll just be calling on you by your area code where you're calling from when you raise a hand. Once again, you have any question, press star five. Okay, public access file. The law says when an H-1B employer files an LCA, within one working day of filing the LCA, they must create a public access file containing the following information. Within one working day of filing the LCA. I'm assuming that at least Anna from our office is here. Let me just see. Wow, there's a lot of people, a lot of companies here. Okay. All right. Yeah, I see her. Okay. Anna, say hello. Anna, say hello.
Rajesh?
Okay, good. So you are unmuted. Let me see who else is here from our office. And there is, I think, Sumanji. Sumanji, say hello. Sumanji?
Yeah, I'm here.
Okay, good. So everybody from our office is here. So Anna, I'm just, if as I'm going through, if you have any comments, please go ahead and interrupt me. It's no problem. Okay?
All right, thank you.
Yeah, of course, Anna, those of you who don't know her, of course, everybody knows Anna and Suman. We've been working together for decades. Um, Sumanji is the general manager of the firm as well as in charge of the green card section, and Anna mismanages the non-immigrant visa section. Um, so between the three of us, they know procedure a lot better than I do, and I think I know a thing or two about law. So we should be able to fill in all the questions that you folks might have. So once again, within one working day of filing the LCA, you must maintain the public access file The public access file must contain the following information. First of all, the LCA. It must contain the LCA. So Anna, what do we do? This is something I'm not quite clear about. Um, the law says I have to put my LCA in the public disclosure file, but I just filed it. I don't yet have it. So do we put a copy of it, unsigned copy of it? How do we do this?
Yes, we put a copy on the file itself, the beneficiary's file.
Okay, so even though we have not yet got it certified, we go ahead and put the LCA copy. Once the LCA is certified, then we put in the certified copy. Is that correct?
That's correct.
Thank you. The second thing they want to see is wage rate to be paid to the H-1B employer. What are we paying our employees? Okay, this particular employee, because public disclosure file goes by each employee. It is not a cross section of the company. That comes differently. That comes later, as we'll talk about it. LCA is, it deals with all, actually, let me rephrase that. LCA deals with all the people, all the employees who belong to that particular LCA. So if you have a multiple people LCA, you have 3 people in the LCA, you can have a public access file containing information about all those 3 people. So the wage rate to be paid to the H-1B worker, and that can be just, if there's nothing else, you can just have a small memo to the file, this is the wage rate decided. It can be a range as well. But the range requires, if you put down a range, the lower end of the range or the lowest end of the range cannot be below the prevailing wage. So if the prevailing wage for a position is $75,000, you can have a range of $76,000 to $300,000. As long as you don't put down 74, which is below the prevailing wage. You can't be below. Okay. So this is the third point, is full and clear explanation of your actual wage system. Actual wage system. Okay. All this information is, by the way, available online. I will also make available a copy of my presentation which contains all this information. So don't take any notes, just listen in. And as I'm talking, please ask any questions you might have. In order to ask a question, all you have to do is press *5 on your telephone. Okay, so third thing is, first LCA, then wage rate that we are paying. Third thing is full and clear explanation of your actual wage system. What does that mean? How do you decide what you are going to pay someone? Okay, some people can, if they are using Mercer survey, they can say we use Mercer survey. Or some people, I have done this in the past, there are people who are experts in the field. They have, for example, if it's technology, they have 20 years of technology experience. They could say, with my experience, I can assess and I know the market. This is how I decide. Whatever it is, there must be some system that has been put in place so the government can decide what the actual wage system is. How do we decide what to pay someone? Some of the newer companies that we have helped set up, we've just simply said we pay whatever the legal wage is required. Along with that, variable bonuses depending upon factors such as employees' performance, corporate performance, employees' technical capability beyond what is normally expected, employees' ability to get along as a member of the team, things like that. You can have variables like that. So when you decide an actual wage system, you could easily say we use OES, Occupational Employment Service, available at flcdatacenter.com. Okay, that's perfectly acceptable. And add with that we have variable bonuses or amounts that are varying from period to period depending upon the following variables, which I just described to you. So that would be acceptable. Fourth thing they want to see is prevailing wage rate and its source. Where do you get your prevailing wage from? If you're using OES, no problem, that's simple enough. But if you're using something like Mercer or another prevailing wage survey, you have to be careful that it meets the requirements. I'm going to quickly run through them. It's not really that important because most people, at least our clients who are all here, use OES. Typical requirements of a prevailing wage source are, number one, it must be recent, most recent version. It cannot be more than 2 years old, must be for that specific geographic area. It cannot be a statewide survey. It must contain mean, median, average, all those information pieces so that there can be statistical calculations about what the wages are. And there must be statistically significant sampling. It cannot be just 3 employers unless the employment is such that it only has 3 employers in the area. And the last thing, if I remember correctly, is, oh yes, it should be somebody who's a reliable a source of information. It cannot be a fly-by-night kind of operation. These are the things that the Department of Labor looks for. Okay, if they don't agree with your wage source, they can make you pay the difference of what they believe the wages should be and what you are actually paying. They can give award back wages. The only good thing is if you have made a good faith attempt, they will not fine you. They will just award the difference in the fees. I want to share a war story with you. This is an interesting situation that happened. Um, During the course of an audit, we saw a pattern which we found very disturbing. Department of Labor is investigating this company, 400 employees. They actually, what they did was, they took the job description with them and went to each employee and said, what level do you think you are working at? If you look at OES, there are 4 levels. Level 1 is entry level, person is still learning. Level 2 is professionally competent but not advanced. Level 3 is technically advanced, who does unusual problems. And level 4 is technical leadership. So, of course, employees are used to writing their resumes. They were thinking we should be inflating what we do. Department of Labor went and talked with each one of them and came back and said, oh, they are all working at level 3 or level 4. And that, in my mind, is something that should not be allowed. If you ever get audited, make it clear to the Department of Labor. If you are going to go talk to my employees, make sure you tell them that your leveling will decide what your salary level is. And these are the 4 levels at which people work. In fact, I usually negotiate with the Department of Labor in the beginning of the audits that certain ground rules should be established. And we can't just have people being questioned about things that they have no information about. And like employees would typically, like I said, they are used to writing resumes. They wouldn't know what leveling means and what the significance of the leveling is. Okay, so I've discussed so far 4 items. I'll go over them real quickly. Because some people are still logging in. Public access file must be created within 1 working day of filing the labor cert or the labor LCA. It must contain the LCA, wage rate that you're paying the worker, what your actual wage system is, how did you come up with that, prevailing wage rate and its source, like OES. Then the 5th question, the notice requirement documentation. So as you folks know, you are required to post a notice in 2 different places. Anna, is it 2, right? It's 2. Anna?
Yes, Rajiv.
Okay,
Yes.
so 2 different places on the premises where the employee will be working. The only change would be if the employee is working from his own house. It might be somewhat different standards that apply. I have a raised hand. Let me just answer that question. Once again, I remind you, if you have any questions, comments, stories to share, press *5 and we can continue talking with different people, get enriched by their experience and questions as well. Give me 1 second. Let me find out who had raised their hand. Okay. Area code 469. Go ahead, please, sir.
Yes, hi, Rajiv. 2 questions actually. One is you mentioned public access file. What does that mean, public access?
Okay, very good question. Very, very good question. I can give you my best professional guess based upon my experience in the field, knowledge of whatever regulations there are on this issue. Public access file is a file that should be made available to any member of the public, any member who walks into your office and says, I want to see your public access files. Do you have the obligation to let them copy it? I don't think so. Do you have the obligation to let them come in on Saturday or a Sunday? Absolutely not. During your regular business hours, if a person from the public comes in and asks to see a public access file, you have to produce it. Was that your question, or do you want me to tell you what public access file is? Just what kind of animal it is?
No, that does. What I was wondering was if it has to be always be made public or only on a request.
No, you don't.
That
Yeah,
an answer
it doesn't have
that
to be.
question. So I guess the HR needs to, on the employee record, keep this information, at least LCA and layer one, in the public, and then the rest of it be, private. So they need to
Absolutely.
differentiate that.
Absolutely. There are actually two sets of
The
documents.
second question I had was, you had mentioned in the LCA application the minimum wage to be paid and the max wage to be paid. Of course, minimum is required. Should or should not, what's the guideline to put the maximum wage rate or salary in that field?
Okay. I was going to come to this discussion a little bit later, but let me do it right now. How much are you supposed to pay? First question. You are supposed to pay the higher of the following two numbers: the prevailing wage or what you pay other similarly qualified employees in that area. Okay, higher of the two numbers. So let's say the prevailing wage is 60,000 for a 5-year experienced software engineer in Austin, Texas, and you are paying them 100,000. Then the wage that you have to pay is 100,000. Okay, it is always the higher of the two, prevailing wage and the actual wage. Number one. Number two, if you have a range, you say my salaries are from 60 to 40 to $75,000 or $100,000. People who fall in that range, you have to have some criteria. Have a spreadsheet that explains how those variations are accounted for. Why one guy is making 60 and the other one is making 75. And I gave you an example. Some of the spreadsheets we have used successfully in the past contained variables like how well the company is doing, how well the employee is doing based upon their performances, how well they act as a part of the team, how technically competent they are, more than normal people, their ability to get you new business. It can also be things like the rate that they are getting at their project. You can make that a variable, a percentage of that. As long as it is clearly described, you can pretty much put down whatever figures you have in your range. You had something else? Go ahead, please.
So again, the upper limit on the wage in that form, is it a good advice to, is it good to put that in there, or just leave it open and still be okay?
Well, you don't
struggle with that.
You don't need to put a range. You can just put a specific salary for each employee and have one LCA for each employee. That's your choice. But if you do put a range, remember, be careful, because if you don't have a good explanation, you could end up changing your actual wage. I've had a situation just recently, actually. Anna and I were working on a very interesting audit. We actually were able to knock off Department of Labor $400 and almost $80,000 from the fine that they had imposed on the company. Then the company came to us, and this was before it was an appeal before the administrative law judge. So I got in touch with the lawyers of the Department of Labor, and we were able to negotiate. In that case, what had happened was, one of the points that Department of Labor lawyers had raised was this: one particular employee was getting paid, let's say, $60,000 a year. Then 1 year he got paid 75. Then they came back to 60. Department of Labor said, you have raised your actual wage. It should be 75,000. So to answer your question, is it okay to put an upper range or nothing at all? Whatever you do, just make sure you don't raise your actual wage if you don't want to. You can always have variable bonuses. That's perfectly okay, as long as they are legitimate, well-defined, and the quantities are basically given in a spreadsheet or something that you can give to the Department of Labor and they can examine it. Does that answer your question?
Yes, thank you.
Okay, excellent. I have 3 more people who have questions and comments. Let me get to them. Let's see, who was next? Old friends and old clients. Go ahead, area code 732. Go ahead, please.
Hi, good afternoon. My name is Sundari. I have a question about the notice of posting you mentioned in two places.
Yes, ma'am.
One is the work premises and second is the company notice board.
No, no,
correct?
no. They are both posted in the work premises. Wherever the employee is going to work, you have to post notices
Okay.
in two places where they are clearly visible to the employees who work there.
Okay, not on the company's notice board.
It can be on company's notice board, not your own, not the employer, but the end client's company notice board.
Okay. Now coming to most of the end clients refuse to post the posting in their notice board. How do we handle that?
You cannot file an LCA and you cannot place an employee there. That is the stand Department of Labor takes in every audit and investigation that I have done. And by the way, non-posting of notices is almost always a ground for debarment from participating in H-1 and green card program from 1 to 3 years. Okay.
Okay, but the client is refused to take the posting.
You
They are
cannot.
not allowing us to
You
post it.
cannot. You cannot place an employee there. It's as simple as that.
Okay.
All right.
Okay.
All right.
Yes, thank you.
You're welcome. All right, let's go on to the next one. We have 3 more questions or comments. Again, New Jersey area code 201. Go ahead, please. 201.
Hi, my question is actually similar to the woman's earlier. Our clients, our employees are all working at third-party client sites, and our clients don't want to be involved in the LCA posting. Can the employee or our employee post this on behalf of the client, or does the client actually have to sign off on it?
Department of Labor doesn't care who posts the notice as long as it gets displayed at the end client site. Can the employee sign it saying that they have posted for 10 days, 10 business days? I don't see any problem with that. I don't see any problem with that.
Okay, and does it have to be posted within the 1 day, or can it be posted once the employee actually starts working at the client site?
From what I remember, I'll let Anna mention. I only know what we do. We put everything up. You have to post the notice. You don't have to wait 10 days to file the LCA, but you have to post it even before. Anna, do we post it before we file the LCA?
Yes, it must be posted before we can submit the LCA.
Thank you very much. So that's the way it works, ma'am.
Client has to post it.
Okay. Okay. Did you get that, ma'am?
Yeah, thank you.
Okay. All right. Let's get on to, oh, we still have 3 more questions. All right. Let's get to our own neighborhood, Virginia. Go ahead, please. Virginia, area code 703-786. Okay.
Yes. Hi, Rajiv. Hi, Sumanji. Wanted to actually ask a similar question regarding the posting attestation notice. We usually get an email confirmation from the vendor saying that the notice has been posted, but we don't get anything after 10 days. So do we need to put anything after 10 days? Just that notice with the signatures, start date, end date when it was.
That's what we do.
taken off the
That's
notice.
what we do. If you have seen our paperwork, on the notice itself, in the corner, it says date notice posted, place notice posted, date removed, and who it was signed by. So yeah, that information should be there ideally. Look, if you have posted notice and it's not 100% in a format that the government wants, you'll at least be safe from probably debarment, because there are good faith compliance defenses available, and Department of Labor recognizes it, that sometimes, despite their best efforts, employers can not be able to comply with everything to a nicety. They're not going to come after you with maximum penalty in those cases. But I do recommend that date posted, date removed, and the place posted should be clearly stated. Place posted can be if it's a company website, a company electronic notice is also permitted. But let's say it's the corporate one was in the corporate kitchen and the other one was in the corporate lobby notice board. Those kind of things should be stated. Okay.
Okay, and both copies need to be put in the put in the public access file.
That is correct.
Okay.
By the way, I want to add one more
A lot
thing.
of times we do.
I want to add one more thing before I forget. A few years ago, the question came up, can we scan the public disclosure files and put them on a publicly available computer terminal? And the answer is yes. I don't see any problem with that. Okay.
Okay.
So,
Okay. If that's the case, that makes things easier. So a scanned copy of the posting attestation can be included in the public access file.
I don't see any problem with that.
Okay, and I have another question regarding the LCA. Is there a way that the LCA can be, signed electronically, or the HR or the management has to sign it in blue and black ink?
It has to be signed. It cannot be electronically signed once it's certified. And am I right?
Yes, Rajesh.
Okay, yeah. So no, they're not making things that easy for us. Not yet. Okay.
Okay. Sure.
Rajesh,
Yeah.
CIS does permit us to submit a signed copy of the LCA once it's certified.
All right, of course, because the same LCA could be used in 10 cases. Yeah, that I understand. What the question was, is there electronic signature permitted on the hard copy or the last format? And the answer is no. Let me go on to the next question. We have 2 more left to go. Let's see. Okay, where are you guys? Here's another one. And another very old, very dear client. Go ahead, Illinois, go ahead, please.
So in the case of an H-1B, let's say when we have to file for the LCA amendment, if can a person start working at the client location while the LCA is pending certification, or if he has to start only once the LCA is certified? Because let's say he was working at location, everything was fine, his H-1B was okay, LCA was fine. He changed his client location within the non-commutable distance, amended LCA was filed. Can he start while the 7 business days are going on, or he has to only start?
My guess is they can start. I'll tell you why. If you look at the language of the LCA requirements, it says that, I think, and I have to double check this, but, and remind me, I can do it for you. The requirement is if you change locations, you have to do a posting of the notice within 3 business days of when they start work there. So I guess here is the presupposition that you can start working even before all the formalities have been complied with. Anna, am I right? Do you remember this off the top of your head?
Yes, Rajesh, that's correct.
Yeah, so I think you can start working once the LCA is filed when there is only an LCA amendment involved. Now remember, an LCA amendment is acceptable only when the client remains the same, the job remains the same, and only thing that you're doing is moving a building within normal commuting distance. If you change clients or you go beyond commuting distance, you have to do an H-1 amendment. You know that.
And if we change client and if we're in the commutable distance, still it has to be
H-1B amendment. Right, because the government is taking the position that we don't know what the new relationship is. We have examined the old relationship and it looks like you have an employer-employee relationship. So even if you are within the same distance, within the same building, but you change clients, we want to know what the relationship now is. Okay?
All right, thank you.
You're welcome. Yeah, things have not gotten any easier. Oh, we still have 2 more hands. Okay. That's all right. I will still be able to finish my discussion. Texas, go ahead again, please. Texas.
Okay. Regarding what the gentleman just now said, clarification. So, is there a difference where just an LCA amendment is is okay versus an LCA amendment and an I-129 amendment needs to be filed when location changes?
Definitely. There's a difference. That's what I just said. I said only an LCA amendment is acceptable only in one case. And that case is this. Your client is the same and the distance is normal. Okay. Anything more than that, if the client changes, you have to file an H-1B amendment, not just the LCA. If the distance changes to more than normal commuting distance, 40, 50 miles, you have to do an H-1B amendment. Okay?
Okay, even though in none of the petitions or forms or, one mentions, there's other things, but in the forms and LCA, you never mentioned the client name, but just the job title and job description. So still the client change
That's right.
does matter.
That's right, because remember, like I said, since the advent of that delightful Neufeld memorandum, we now have to prove to the government in every case that we have employer-employee relationship with our own employees. So if you put them with a new client, they want to see that that relationship is still being maintained.
Okay. The original question that I raised my hand for was, and again, just again clarifying, the posting of the job at the client site versus posting it at our office location, so the principal, business location, that really is not acceptable.
It is not. It is not. The only choice is in maintaining the public access file. You can maintain the public access file at your principal place of business or where the employee is working. But posting of notices always follows where the employee is working. Where the employee is working from home, they want us to post in the end client premises. Okay?
Okay. And this is more relevant, of course, to the green card process, right, than the H-1 process.
No, this is the H-1 process. Green card process, you will always, if you have a consulting job and the job is being advertised from the corporate headquarters, you will always post in-house, not at the client side.
So then if the person may not even have started at the client side yet.
That's right, but you still have to post it.
Then
you still have to post it.
Okay.
I want to caution everybody about something. Two things I want to caution you about. One is, last 4 or 5 years, I have assisted many corporate criminal defense teams where companies were being prosecuted in various areas of this country by the federal government, FBI, for crimes related to immigration violations. A new count for the last 4 or 5 years under criminal law has come up almost in every case that the employer, the H-1B filing employer, hired people without having a specific project in hand. That has become a criminal offense. Number two, 2 weeks ago or 3 weeks ago, maybe a little bit more than that, I was asked to review an indictment. And there are two things notable about that indictment. Indictment is basically a beginning of the criminal proceeding. Okay. Number one, the employer was being indicted for non-payment of wages, benching. I have not seen that before. I'm very doubtful that can be sustained, but the government has made that effort. The second thing I noticed about that case was the indictment was started through an affidavit from the Office of the Inspector General of Department of Labor. Typically, when there is a criminal case, there are multiple agencies involved. FBI, Department of Labor, State Department, USCIS, ICE, but this one was only Department of Labor. That makes me feel that they are being very proactive and aggressive now about criminal enforcement. Very strange. But just keep it in mind, you can never file without a specific project in hand. Okay. Now, we still have one more question. Let's address that and then we can go on. California, go ahead, please. California?
Rajiv, when we file the quota cases,
Right.
and few of the employees are reporting only in October for the work, is there still a timeline within which we have to do the posting notice? Because basically the employee is not even, here. He has to fly for the project in October.
That's irrelevant. The posting belongs to the LCA, not to the employee. So when you file the LCA, you have to comply with all the requirements. In fact, you sign under penalty of perjury that you have complied with all the requirements. Perjury is a criminal offense, a felony punishable by, I think, 5 years in prison. So when you sign an LCA, every time you sign an LCA, you are swearing or committing to the government under penalty of perjury that all the requirements have been complied with. Whether the case starts in October, November, December, irrelevant. If you're filing the LCA now, you have to comply with the requirements now. Okay? Hello?
Thank you.
You're welcome. Okay, we have still one more hand. All right, let's get to that. And this one is Pennsylvania. Go ahead, Pennsylvania. Pennsylvania.
Hello.
Yes, go ahead, please. I can hear you. Hello.
Yeah, actually, this is. We said that when we file for the LCA amendment, the beneficiary can start working at the client side. But what happens if the LC is not approved? Then what happens for the H-1? It will any effect on the H-1?
How many times have you had an LCA not approved? Just curious. Very rarely. Okay, now I did not say that I'm 100% sure about this, but I guessed based upon language of the requirements that I have seen, language of the regulations that I have seen, that once you file the LCA, it should be okay for the employee to start working there. Now here is the clincher. If the LCA is not approved, whatever little chance there is of it not getting approved, then the employee could be considered to be working there without authorization, which could put him or her out of status. But since it is a violation that is going to be of a very brief period of time, hopefully the government will forgive it if the time should come. Okay?
Okay, thank you.
You're welcome. All right. And we still have one more question to go. Okay, that's good. That means nobody is asleep yet. All right. New Jersey, go ahead, please. New Jersey.
Yes. Hi, Rajiv. A question. Since we need to file the LCA or post the LCA rather at the client side before the individual commences work, can an existing resource of the organization attest if they are willing to the fact that this was posted at 2 locations?
I have no problem with that.
But does the individual have to?
No. There is no requirement that the employee who's going to work there himself has to post. Anybody can post on behalf of the employer. I don't see. That's not a problem at all.
And it could be for.
Go ahead.
So it could, let's say that it could be in one place which is conspicuous like a notice board, and could it be a second location like the existing employees' own cubicle space?
I wouldn't do that. It has to be in 2 places that are visible, conspicuously visible. So no, I don't think an employee's own cubicle is conspicuously visible to the rest of the employment, to the employers. The idea is the people who work there should be able to see it. Okay?
Okay. Thank you.
You're welcome. Okay, so that wraps up our question round for this one. Let's go on. So notice requirement was the fifth thing that I discussed. LCA, wage rate that we are paying, actual wage system explanation, prevailing wage rate and its source, and notice requirement. Okay, let's go on to the next issue that comes up. Summary of fringe benefits that we pay our US workers and H-1B workers. So whatever the fringe benefits we pay, normally they are common across the board. You can have just a memorandum that says these are our fringe benefits. I know employers who put in excerpts, copies of their employee handbooks that tell what those fringe benefits are. Okay. There's, in the case of a corporate takeover, certain formalities are required. The presentation that I will post online, and I'll send you links to all that, it will have all those lists, so you can take a look at that. Basically, it's pain-free. If the H-1 employer is successor in interest, it just requires some internal documentation. It does not require refiling of everything with the government. Okay. Then under the Internal Revenue Code, there is a definition for single employer that goes towards calculation of whether or not you're H-1B dependent. That has to be there. Ninth thing on the list is your list of exempt H-1B employers, those who have the US equivalent of a master's degree or are getting paid $60,000 or more. Then for H-1B dependent employers, you also have to put down the summary of your recruitment methods. How did you try to recruit US workers before you file the LCA? Of course, this is not applicable to those employees who are exempt. I want to make a distinction clear here. When employees are getting paid $60,000 or more, or have the US equivalent of a master's degree in a relevant discipline, you don't have to do the things that you normally have to do for H-1B as H-1B dependent employer. What does an H-1B dependent employer have to do? Two things, in addition to a normal employer. You have to show that you recruited through internal, external, active, passive recruitment. I'll come to those definitions in a second. You tried to find workers and you could not. Interview them, document that. Second thing you have to do is you have to make sure that you're not displacing US workers in your own workforce or in the end client's workforce if you are placing people there under indicia of employment. Basically, if the end client controls, you've got to make sure they're not getting rid of their local workforce, replacing them with H-1B workers. So two requirements in addition to normal employers. One requirement is the recruitment of US workers, and second is making sure there is no displacement. And I'll come to those. So that's also part of the public access file if you are an H-1B dependent employer. Two kinds of displacement, direct and secondary. Direct is when you are letting people go, US workers from your own workforce, replacing them with H-1B employees. Remember, once again, it does not apply. You don't have to do all this for those people who are getting at least $60,000 in wages or have a master's or higher degree related to their discipline. Okay. Once again, I remind you, you have any questions, comments, concerns, press *5 and I'll address them right away as we are talking. *5 on your phone. Okay. Then we come to, let's see. I talked about direct displacement. I talked about indicia of employment relationship, which basically means if you are a contractor and you're placing people at an end client site, if there is any kind of indicia that the end client is controlling, you might have to make sure that secondary displacement requirements are complied with. I will come to that also a little bit further up the road. I just want to quickly give you a list. So these are the basic requirements for the public disclosure file. It's not complicated. So far, it's quite simple. The list of the documents is quite simple. What you're supposed to do is quite simple. The devil is in the details. Sometimes when you have all these variations, like other people have talked about just a few minutes ago, that's when you start scratching your head and saying, well, what am I supposed to do now? Call your lawyers. The right thing to do is call us. You know, we don't charge by the hour. So if you, especially companies that we work with on, sole source basis. We never charge for our time in addition to what we are already charging them. So call us, make sure you have proper information before you implement any changes in your policies or procedures. Okay. Additional records that are required, this is not for public access, but the government can ask for it. So you should maintain them and have them ready because government can ask for it. You don't have to put it out for the public. These are records like for each H-1B worker and each US worker in the same occupation on the same job site, name, address, occupation, social security number, period of employment, area of employment, petition package, subsequent LCAs for each worker. There's a bunch of requirements. I'm going to give you a list of them. It'll be all published and we'll send you links. Monica has all your email information. In case you don't, you're welcome to write me directly, help@immigration.com. That's my email. Most of you know it. Help, H-E-L-P, help@immigration.com. Then you have to maintain documentation about the rate of pay, hours of work, gross pay, deductions, net pay, your typical tax records. Okay, so there's nothing complicated about that. Again, I mentioned you have to do the fringe benefits plans. Make sure that copies of that are maintained. Government can ask to see those as well. They can ask to see all your LCAs. They can again ask to see your wage rate system, etc., etc. But that's already a part of your LCA file. The only difference is there we were talking about individual file. Here we are talking about corporate wide. They can ask for all your paperwork. Okay. The last item that I wanted to discuss here was, again, what I talked about earlier, that single employer definition, which is important for dependency calculations. That should also be maintained, have it ready. I'll tell you something. Some of these additional documentation, if you don't have it right away and it's going to take you 3-4 days, government is very understanding in these cases. We've never had problems getting some extra time as long as we are doing things in good faith. So I don't advise you not to have this, but try to have as much of this as possible. And like I said, I'm going to give you a list. If you cannot, or if you have a problem with something, we can do more of these conference calls. The reason I did this today was we have a new corporate employer who wanted us to provide them some information, and their HR people are on the phone as well. So I wanted to do it for everyone because there are things that need to be brushed up, and there are questions that people might have. And most of you are existing clients. I think all of you are existing clients. So if there is, any issues that are repeatedly coming up in practice, we want to address them for you. The H-1B dependent employer or willful violators, they are treated the same. Willful violators are people who earlier during an audit were found to be violators. Okay, they have to maintain their list of dependency calculations. Some of this information is repetitive because it's coming from different source, but the idea is the same. You can as long as you follow these guidelines and maintain. Public disclosure file should be complete, but everything else, as long as you know you can get it together within an hour or two, you're okay under immigration law. Okay, and if you are an H-1B dependent employer, for your recruitment, for those employees who are not exempt, less than 60,000, not master's degree, you have to show what recruitment methods you used. You have to show date and copies of the ads, postings, compensation that you offered, any documents you created for the interview, why did you reject the candidates. So those kind of things, you have to maintain them, sort of like what you do during labor certification perm process. Okay. Interesting thing is, for displacement at an end client site, Department of Labor says it is okay if you have language in your contract that says it is understood that if we place employees with you of 90 days before placement and 90 days after placement, you will not, Mr. End Client, displace any US workers in that area, in that geographical area for those kind of jobs. So you can actually have it in the contract with the end clients, and I've seen that with a lot of our people. I've seen that language in the contracts with the end clients. But if that's not possible, emails from end clients and emails to end clients is a good idea. Guys, do you know you cannot displace any US workers 90 days before the placement and 90 days after the placement? So um, you can also make notes. If you call somebody and you call James Smith at IBM and said, look, James, you are not supposed to displace people, make a note the same day that you're talking. It's called contemporaneous notes. Make a note, I talked with James and on this date at this time and explained to him there's no displacement. He understood. Put that in the file. That's good enough. Okay. They also want to, Department of Labor can ask you for last known addresses, personnel records, pay records, etc., etc. Be prepared for that. For the recruitment of the US workers, they require that you must give fair consideration. You cannot make excuses. You cannot make screening criteria that are basically skewed. For example, you say, I require Telugu as a language requirement or Hindi as a language requirement. Okay, there's a question. Give me 1 second. Let me finish my thought and I'll be right with you. So, okay, let's take the question first. There is recruitment, prior to filing. So basically recruitment involves that most of the people we work with, we've never had a non-exempt employee. Everybody has been an exempt employee. So, but let's get to the question.
Hello, Rajiv.
Yeah, go ahead, please.
Chandra, good morning.
Good morning.
Hi. Sorry.
You are from Arizona, right?
Yes, I am from.
Yeah, go ahead, please. Go ahead with the question.
I'm sorry. I think I'm sorry to disturb. I mean, actually, I have a question. Actually, maybe after you complete this, I can ask. I thought I can.
Yeah, after yeah, if it is not related to an LCA discussion, stand by. I'll finish the recording. I'll stop the recording, and then we can talk. Okay, just hang tight.
Thank you, sir. Thank you.
My pleasure. Sorry. My pleasure. Okay. So from the recruitment topic, then there are some additional requirements, what kind of documents you're supposed to maintain. I'm not going to worry about that. Most people don't have to do recruitment. I also want to mention recruitment is internal, external, active, passive. Department of Labor wants to see all of them. Internal is you are recruiting by posting notices within your own premises. External is when you are looking outside of yourself. Active is where you go to job fairs. You actually go look for people. Passive is you advertise. They want to see all of these things in some measures if you are an H-1B dependent employer or a willful violator and you are recruiting for non-exempt jobs. Okay. One very, very important topic, payroll deductions. Now, this is not really a part of your LCA file or anything. That topic is over. But I have seen this become a major problem. The general rule is you can never deduct from an employee's salary any amount. No amount at all. You can sue them if they owe you money, but you cannot deduct from their wages. Okay? Unless it is done with their consent and for their convenience. I would suggest if you're making any extraordinary non-governmental deductions, for example, healthcare, their portion, get something in writing that says, dear Mr. Employer, can you please, for my convenience, make these deductions and submit them directly to the healthcare administrator. Okay, so the deductions that are allowed are these are deductions from the employee's paycheck, whatever is required by law, whatever is reasonable, customary, in compliance with other laws, and is disclosed to the worker. Okay. The repayment of loans and advances as long as it is voluntary. Again, if the employee borrows money and they say, can you please deduct it from my paycheck, get that in writing, and that should be okay. I don't see any problem with that. Can you recoup housing costs? What if you have given them housing? And the answer is usually you cannot unless it is for the employee's convenience. So if for the employee you created some housing situation, you can recoup that. Again, if it is a payroll deduction, make sure you get something in writing from them. Okay. You can never deduct business expenses, your business expenses, such as tools, business travel, those sorts of things. And Department of Labor makes it clear that home to work commuting costs are not your business expenses. Okay. It's an important topic. What is and what is not business expense? There has been considerable litigation on this. There's a case from Tennessee, not Tennessee, I forgot the state. It's the Dr. Manohar Kutti's case, in which the federal court said that, I think it's Tennessee, that even expenses such as attorney's fees for H-1 processing, waiver processing for J-1 physicians, these are all ordinary business expenses because that's your business. You should be paying it, not the employee. So it used to be that it was okay for employees to pay for the lawyer's fees in H-1B cases. No longer. Department of Labor has taken that position. They started from that position in Tennessee, I think. And by the way, that case is under appeal right now in Tennessee Federal Courts of Appeal for that circuit. So the court said, everything is ordinary business expense if it involves employer's benefit. But there is, of course, an exception if there is something that involves employee's benefit. For example, employee says, I've got this unique situation about my status. I want to talk to the company lawyers, or I want to talk to the counsel company uses. Can the company make him pay the fees for that? And the answer is yes, because that's being done for the company's, for the employee's personal benefit. Okay, I have one raised hand. Let me get to that. Go ahead, please.
Yes, I have a question regarding the premium processing. Does the employee pay the premium processing if it's not company, if the company does not need it?
I have said that it is. As long as you document it, and you are from Illinois, as long as you document it, okay? For example, I don't want to do premium processing. I'm fine with regular processing. The employee comes to me and says, look, I really need premium processing because I want to get together with my wife, or I want to travel after getting visa stamping. Get something in writing. Even if it's an email that says, look, I have personal reasons. I would like to pay for it. Can you please accommodate me? I think it's okay.
Okay, thank you.
You're welcome. Okay. Now, I want to discuss a very, very important topic, guys. And I'll tell you this. I have seen contracts from Fortune 50 companies that have this problem. It is not a problem confined to smaller employers. What is referred to as liquidated damages. Liquidated damages. When you have liquidated damages in the contract, I have a whole article on this. It's a 30-40 page article that was published before American Bar Association, American Law Institute, I think last year. And if you need a copy of that, just drop me a line, help@immigration.com. I will send you a copy, or firm@immigration.com. It's on our website. So basically, there are situations in which an employer and employee decide, look, we are going to hire you. We are going to employ you. But if you leave us before your contract is over, whether it's 2 years or 3 years, it can cause us damage that we don't really know how much it could be. So we'll set up a reasonable figure, 25,000, 10,000, 8,000. And if you leave us, you have to pay us that amount. I've seen that very commonly. Department of Labor has been charged with the responsibility of determining whether something is an early cessation penalty or liquidated damages. Liquidated damages are okay, but penalties are not okay. The problem is you get hurt as employers if Department of Labor starts investigating, because they're supposed to come and investigate. They can get into all sorts of things. It can become legally expensive to comply with the Department of Labor requests. So be very careful with those liquidated damages clause. That is a topic that will require at least a half hour by itself, maybe more. Generally speaking, bad idea. Read my article, have your contract lawyers read it, There's actually an article being written right now, a fairly lengthy investigative piece of journalism. I worked with those reporters for a few hours actually, explaining to them what I thought was wrong with this whole picture. So be careful with the liquidated damages clause, where the employee is required to pay a certain amount if they quit you. You can sue them for whatever the actual damage is. It's the liquidated damages clause that becomes a problem. Okay, no questions so far. I want to add one point. Any unauthorized deduction from wages is considered to be non-payment. So it's as bad as not paying the employee. You can never withhold payments, including a final paycheck. Sometimes people hold final paycheck saying this guy just quit, never informed me. You give them the money and you sue them. That's fine. But you don't withhold their paycheck. Okay. There is a whole series of things about what penalty and liquidated damages are. I'm going to skip over that part and leave that for another day because I do have it written down. The article is quite comprehensive. It should be understandable by both lay people as well as lawyers who are here. Expenses, I have covered most of it. Personal interest of H-1B worker, you can get that back. Transportation, if you pay them to come from their home country, you can get that back. Again, don't take it out of the wages, but ask them to pay it back to you. That's the better policy. Food and housing, I've discussed that. If it is benefit of the H-1B employee, you can probably get it out, but make sure you talk with your employers just to make sure that these payments are okay. Okay. I have some definitions: actual wage, required wage, etc., etc. Those I've already discussed in the beginning of this conversation. One very important concept: when does your obligation to pay the wages begin? Okay, when does it begin? The general rule from the Department of Labor is you have the leeway. This is not USCIS, this is Department of Labor. You are dealing with regulations from very many different agencies. USCIS may have different standards, but Department of Labor says if you hire somebody locally, you have 60 days to place them on your payroll after the petition is approved. 60 days from the H-1B petition approval. If they're coming from outside USA, you have 30 days. Okay. But here is the clincher. However, if they enter into employment before that, you have to start paying them immediately. What does that mean? And this is the definition I'm reading. This is important to understand. Enter into employment occurs when workers first make themselves available for work or otherwise come under the control of the employer. So if they report to you or they come under your control, whether it is through waiting for an assignment, reporting for orientation, training, going for interviews or meeting with clients, studying for a licensing examination, everything, the moment they start doing that, they've come under your control. So then the 30-day, 60-day rule goes out the window. You have to start paying them right away. Keep this in mind. This has been an issue in many audits that we have done. Okay, employer did not realize that they had to start paying them even though the employee had not technically joined. But the fact that they reported and they said, I'm ready to work, you have to start paying them right away. Record retention is an important question. I'm asked that a lot. So general rule is for the LCA, you have to retain the LCA for at least 1 year beyond the last date on which you employed any H-1B worker under that LCA. So if you have 3 workers, one left in 2003, another one left in 2004, another one left in 2005, last worker left in 2005, you have to maintain LCA documentation till 2006, 1 year beyond the last, when the last worker left. If you did not employ workers or if you withdrew, 1 year from the date the LCA expired or the date you withdrew it. If there was nobody who was employed on that LCA, 1 year beyond the date the LCA expired or you withdrew it. Okay. All payroll records for 3 years. from the date of the creation of the record. And if there's an enforcement action, if there is something going on, like an audit investigation, you have to maintain all records until the investigation is over. My strong recommendation, do not maintain records beyond what is genuinely required. Why? If you have the records, government can get into them. If you don't have them and they are legally destroyed, I see no obligation to try to recreate them. Okay, that's perfectly legal, and you should go with what is legal. These were all the issues I wanted to discuss with you today. The only thing I skipped was a lengthy discussion on liquidated damages issue. General rule, don't put those clauses in there. If you have them, please discuss them with me. Okay. I have nothing else to add, folks. Any questions, any comments? This took us 1 hour, 5 minutes. I had planned on about 1 hour, 15, 20 minutes. So we have time. Anybody has any questions about what we have discussed, go ahead. If you have no questions about LCA or compliance, I will stop the recording and then we can talk about other issues that people might have. No questions? *5 for any questions. *5. Very well. Let's stop recording then. And I thank you all for being here. People who have other questions, stay on. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.